Hello, I'm Frank Feehan of 1KBW. I'm a barrister there.
I'm Caroline Harris. I'm a barrister at 1 King's Bench, Walsall.
We're talking about what happens when you're in the middle of a case and all of a sudden the prospect of having to deal with the vulnerable witness provisions either in crime or family arises. I've got recent experience of that happening where in a case where children are going to have to give evidence, not only have a number of other children, as it were, come out of the woodwork as witnesses in a fairly significant sexual abuse accusation, both giving evidence both potentially for and against the accusations. But no one actually had grasped with the point that there were children involved in this case at all. And so we haven't even had a re-W exercise conducted, even though the case is due to start today. Does that happen in crime? Or is it better regulated than that?
Actually, very often the first hearing is a hearing where you have to deal with the unknown. So it'll be the first time, especially when you're a defence barrister, where you've met the defendant. It may be the first time that anybody's really put their minds to whether or not they're vulnerable. So I had a recent case where I met the client at court for the first time. He'd had his police interview, but that was the first time he was really being dealt with by his professional team at court. And I started speaking to him. It was very clear he was cognitively challenged. So I had to be ready at that point to say to the judge he wasn't fit to plead. As it turned out, we had him assessed and had an IQ of 43 and was found not fit to stand trial. But actually knowing the procedure there and then at court and being able to say to the judge, I don't want him to enter a plea because I want him to go through these hoops at this stage. You have more weight with a judge if you know what the rules are and you can stand there and argue them. Whereas if you just go in and say, I'm not particularly sure about what to do with this client at this point in time, can we adjourn it? Then that's not going to be successful. Whereas actually what we did is we timetabled it through. When we went to the next hearing, because I'd then by that point got my psychologist report, psychiatrist report and intermediate report, all of which asserted he wasn't fit to stand trial, the judge put pressure on the Crown and they offered no evidence, which went really well, obviously.
Did the fact that you've helped and put together a handbook on this help you to deal with that situation? Because you must have had things at your fingertips.
Well, actually, I had the points to go through, so it was very helpful. I had our checklist, so I could actually say to the judge, well, what we'll need to do is these steps. And the judge was very happy to follow those steps. I even put together a note then for the second hearing, setting out the rules and law, which meant that he knew exactly what I was asking him to do. And in fact, the Crown also followed my checklist, and so we got the right result.
Good. As it happens, in my case, I had to do an advice over this last weekend, and having the draft of the handbook in front of me really helped me put that together, because we've had to put together the rules and the authorities that back up those rules. Well, we'll see what the outcome is this morning. There's going to be an application to adjourn that case, and we'll see whether or not that succeeds.
But very often that's what the judge wants, is just the bullet points of the law, so that they know where they've got to go. Because if it has just arisen in court, actually that's what they need to know. How do I need to deal with this right now?
Well, the hope is, in what I've just done over the weekend, is that the judge is reassured that she's able to look at the rules properly, that she's taken through the appropriate authorities, and, in a sense, given the appropriate warnings that trying to push ahead with the case, which isn't really ready. There are Court of Appeal authorities against that, there are specific authorities on it, and those, of course, are contained in the book. So let's hope it works.
No, indeed. I mean, I helped a colleague out at court a couple of weeks ago, where the client had gone downhill, so a defendant, middle of the trial, suddenly couldn't participate within it. They were saying, what do they do at this stage? Because can they now raise fitness to stand trial at that point in time? I was able to say, well, actually, I can point you to the law. You see this, give them a sneak peek of our handbook as it comes forward and say, well, actually, you can. And the judge has a duty to actually consider the fitness of a defendant throughout the course of the trial.
Well, I had a case recently in Birmingham, which was an enormous case and lots of QCs involved, where what I thought was a tactical decision being made to try and have someone treated as a vulnerable witness who just wasn't really a vulnerable witness. So on that side of the thing, I had a material available to me to say, well, if you look at the criteria properly to the judge, this is actually a tactical approach rather than a substantive approach. I was able to fight off the notion of someone being treated as a vulnerable witness, which would have been quite detrimental to my own client because of the shifting loyalties and the shifting evidence in that case.
And there is often a balance between vulnerability and the right to a fair process for everybody else present. I mean, in crime, that's one of the key problems effectively with vulnerable witnesses, because you're in front of a jury. So if you have that vulnerable witness having special measures, there is often a concern about how they will be perceived by the jury. And although there are directions given by the judge, as a defendant, for a defendant, actually you can see that balance is a hard one to strike.
Well, what we do in the book, I remember in chapter 1 of the book particularly, we deal with the ordinary rights and duties of cross-examination and the right that a defendant or a respondent party has to put their case properly, to properly cross-examine a witness. And so often, perhaps not often, but certainly sometimes, it's as well worth having the material at your fingertips so that you know when not to call someone a vulnerable witness and so that your client has his rights fully asserted in cross-examination or in submissions. And so it's useful, it seems to me, to have that right in front of you and with you at call.
Indeed, and we've both seen from the recent case of Hayden J pointing out that if that balance isn't struck properly, then in fact actually what it will lead to is a retrial, which is the worst thing possible for somebody if they are actually vulnerable